Hello and welcome everyone. We welcome you once again to Vestralex free online community classes on law. This is your initiative by you, for you, and possible only through the generous contribution of our seniors, guides, and mentors. Today, we have the good fortune and opportunity of learning from one such legal luminary, Srimati Sonia Mathur ma'am. She's a senior advocate and one of the most esteemed and one of the most, how do I say, caring person as a faculty. Also, I would say anyone. I'll come to ma'am's introduction, but before that, I want to just most humbly mention that I'll request you to please search for ma'am online. I'll request you to search for her on YouTube as well. You'll find so many videos of ma'am, and you'll just fall in love with how she teaches you, how she guides you, and how she breaks things down. So that is the reason why we brought to ma'am some very unique, a broken topic, so to say, but she fixed it. So the topic is, as we know today, the rights of an accused person, but we'll see ma'am's perspective on it. But before I hand over the class to ma'am, I welcome ma'am and I'll take the permission to introduce her. Ma'am, thank you so much. So Ms. Sonia Mathur is a senior advocate. She was designated by the Delhi High Court in 2017 as a senior with over 3 decades of distinguished practice. She appears regularly before the Supreme Court of India, various high courts, and specialized tribunals covering income tax, competition law, and consumer protection. She has previously been a senior executive member of the Supreme Court Bar Association. Mrs. Mathur holds a master's in labor laws from the University of Rajasthan and a master's in taxation from the Washington School of Law. She currently serves as the counsel for the Union of India before the Supreme Court and has been appointed the special prosecutor in significant matters, including the 2G spectrum scam. She has served as a standing counsel for the CBI, Income Tax Department, and the state of Rajasthan, and led the team representing the NIA in the Kerala twin blast case. A sought-after speaker, she is regularly invited to the National Judicial Academy, Bhopal, and the Delhi Judicial Academy. A resource person for judges and legal professionals, she has argued numerous landmark cases, acted as amicus curiae in the death sentence matters, and represented stakeholders in public interest litigations related to the Northeast Delhi riots. Ms. Mathur has also been on the editorial team of the 11th edition of the Kanga and Palkiwala on income tax, reflecting the deep engagement with legal scholarship. Ma'am, very warm welcome to you. And ma'am, we are grateful to you and we hand over the class to you.
Thank you very much, Keshav, for an extremely kind introduction. First of all, let me congratulate you and huge appreciation and acknowledgement from my side for a wonderful initiative by you. And thank you very much for giving me an opportunity to be here and talk to everyone here. Now, the topic which has been given to me is rights of an accused person. Now, see, they say that better that 10 guilty person escape than one innocent suffer. This is a phrase which is often attributed to William Blackstone, who was an English jurist. However, in our system, this certainly signifies the importance of presumption of innocence, which occupies a huge space in our legal system. Even our Supreme Court has repeatedly said that the state and its officials cannot take arbitrary and excessive measures against the accused, or for that matter, even against the convict, without following the due process sanctioned by law. So in our country, in our system, it is not that the rights of an accused will be exhausted once the person once the person is convicted. The rights are extended even to the convicts. So I'll just break the topic into a few sections. Like one is the importance of right of an arrested person in a democracy. I'll be addressing two aspects of the right of an accused. One is during the investigation and then during the trial. So first is the importance of right of an accused person arrested person in a democracy, and then the relevant constitutional provisions. And then I'll place before you certain built-in safeguards in the laws which are governing criminal proceedings in our country. And then I'll support that by a few judgments just to demonstrate as to how our courts have really stood up to protect these rights which are guaranteed by the statute. So, so that it's not clear, it's not only for the optics, these rights are in the spirit of the system. Now, in a constitutional democracy like ours, like India, the power to arrest is necessary and is at the same time deeply sensitive. It can be the most coercive power of the state, which is actually meant to ensure an effective and fair investigation, but at the same time extremely important for maintenance of law and order, etc. Now, this arrest of a person is considered to be the most direct intrusion into the personal liberty of an individual. And if it is unchecked, if there are no system to really guard the arbitrary exercise, it has the potential to be oppressive, arbitrary, and a completely violative of the individual rights and dignity. Now, under our constitution, the delicate balance which has to be maintained in between the state's duty to investigate crime and an individual's right to liberty. There are certain articles which are reflecting the clear acknowledgement of this balance. First is the Article 21. Now, what does Article 21 say? It says no person shall be deprived of his life or personal liberty, except according to the procedure established by law. Now, Article 22 says protection against arrest and detention in certain cases. Now, an arrested person has to be told the reason for his arrest, and he also has a right to consult and be defended by a lawyer of his own choice. Now, any person who's arrested has to be mandatorily produced before a magistrate within 24 hours, excluding the travel time. And it cannot be kept longer than this without the specific orders of the magistrate. And these rights, however, do not apply to persons who are detained under preventive detention laws. Their preventive detention of a person also cannot exceed 3 months unless there is an advisory board of High Court judges which approves it, subject to the limits set by the Parliament. Now, even a person who's detained preventively under the preventive laws has to also be informed of the ground of detention and given a chance to make a representation as early as possible. Then Article 20. Article 20 of the Constitution says, no person shall be convicted of an offense except for violations of law in force at the time of commission of the act, nor be subjected to a greater penalty than that which might have been inflicted under the law in force. So therefore, I can only be punished or convicted for an offense which is a violation of a law which is in force at the time of commission of the act. And then no person shall be prosecuted and punished for the same offense twice. The third, which is Article 20, sub-Article 3, it says no person accused of an offense shall be compelled to be a witness against himself, which is the right against self-incrimination. Now, all these provisions actually make the first line of defense against unlawful detention by the state authorities. And these are not merely procedural formalities, but actually are fundamental safeguards that these are inserted to prevent the misuse of police powers and also to preserve the dignity of the individual and ensure that justice is done. Now, rights of an accused person during investigation. Now, this was with regard to the rights of a person when somebody is arrested, and these are the constitutional safeguards. Now, when it comes to the provisions under statutes which govern the criminal proceedings, so rights of an accused person during investigation. So when investigation cannot be completed within 24 hours. Now, the relevant section of the CRPC was section 167. However, under Bharatiya Nagrik Suraksha Sanhita, which is the BNSS now introduced, is section 187. Now, this section says that if the investigation cannot be finished within 24 hours, then police must send the accused and case diary to the nearest judicial magistrate. And the magistrate, subject to his orders, can keep the accused in custody, either police custody or judicial custody, up to 15 days in parts. Now, total detention period is 90 days for certain offenses which are punishable with death or with life imprisonment or 10 years, etc., and 60 days for other offenses. Now, after this time limit expires, which is 90 days and 60 days for completion of investigation, the accused must necessarily be released on default bail if he furnishes surety. And accused must also be produced before the magistrate, initially in person and later either in person or through video link. Now, the Article 20 sub-Article 3, which we just read, which is protection against self-incrimination, Section 161(2) and Article 20 sub-Article 3 are the relevant provisions. And now it is Section 181 of the BNSS, which says that any statement given to the police not to be signed and cannot be used in evidence. It says that a statement made to the police during investigation cannot be signed by the person and cannot be used in trial, except as allowed subject to certain conditions in the statute. Now, if a prosecution witness has given a written statement, the accused, and with court's permission, the prosecution, they may use it only for the purpose of contradicting such witness under Section 148 of the Bharatiya Sakshya Adhiniyam, which is the substitute of Indian Evidence Act. Now, the Section 182 of BNSS, it says no inducement offered. Now, subsection 1 says no police officer or authority shall give any inducement, threat, or promise as mentioned in Section 23 of the Bharatiya Sakshya Adhiniyam. But in any case, if somebody wants to voluntarily make a statement during investigation, it can certainly be done. That is subject to Section 184, subsection 4. Now, Section 183 of the BNSS, that talks about recording of confessions and statements. A judicial magistrate may record any confession or statement during investigation, even if he has no jurisdiction. It may be recorded in the presence of the accused advocate, and a police officer with magistrate powers cannot record such confession. So confession has to necessarily be recorded by a judicial magistrate. And before recording, the magistrate has to tell the person who's making a confession that it may be used as an evidence against him and he's not bound to make a confession. And it will be recorded only subject to the satisfaction of the magistrate about the voluntary nature of the confession. And if the person refuses to confess, if he's on bail and refuses to confess, then he cannot be sent back to the police custody. Now, so far as the procedure which is to be followed when the person is making a confession, it is in Section 316, which says that the entire examination should be recorded and the person making it must be made to understand in the language known to him. And then it can be signed and certified by the magistrate as voluntary. Now, if the victim is mentally or physically disabled, an interpreter or special educator must assist, and the statement should be recorded by audio-video means. Now, then comes right to medical examination. Medical examination has to be carried out when a person is arrested. And the copy of the document, copy of the medical documents which are prepared by the medical officer have to be necessarily furnished to the accused person or anybody who's nominated by the accused person. The relevant sections are Section 54 of CRPC, 53 of CRPC, and Section 51 of BNSS. Now, this examination of accused is done at the request of the police also, because it is basically for gathering evidence. And if the accused is a female, then the examination has to be necessarily conducted by a female medical practitioner. And then it's the right to legal representation. This is derived from Article 22, Sub-Article 1, and there are various landmark judgments of the Honorable Apex Court. However, Section 38 of the BNSS gives an explicit right to meet an advocate during interrogation, although it says not throughout the interrogation, but certainly meet the advocate. And then, of course, we have provisions of bail, which are bail in non-bailable offences, Section 437 of the CRPC and Section 480 of the BNSS. So when a person is released on bail, I will not take you through the sections because they are available and everybody has access to the specific sections. Now, when bail is granted, then certain conditions can certainly be imposed by the stage of granting bail, such as that the person shall attend in accordance with the condition of the bail bond, which is, if it is an anticipatory bail, then the person concerned is bound to participate in the investigation. And sometimes, the allegation, considering the allegation, there is the accused is stopped from traveling outside the country, passport, etc. is kept. And also one of the conditions that is usually put is that shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the facts of the case, so as to dissuade him from disclosing such facts to the court or the police officer. So, and if at any time after the conclusion of the trial of a person accused of a non-bailable offense, and before judgment is delivered, the court is of the opinion that there are reasonable grounds for believing that the accused is not guilty of such offense, then such accused can be released if he's on custody on execution of bond. Then, of course, we have the provision of anticipatory bail, which was under the CRPC, it was Section 438, and in the BNSS, it is Section 482. And this is a provision which I'm sure all of you are familiar, but it says that where any person has reason to believe that he may be arrested on accusation of having committed a non-bailable offense, he may apply to the High Court or to the Court of Session as a coordinate jurisdiction for a direction under this section that in the event of such arrest, he shall be released on bail, and that the court may, after taking into consideration the factors which are taken into consideration at the stage of granting of anticipatory bail usually are the nature and gravity of the accusation and the antecedents of the applicant, whether he's previously undergone imprisonment or conviction by a court in respect of any other cognizable offense, and then the possibility of the applicant of fleeing from justice, meaning frustrating the trial, basically frustrating the trial or the investigation. And so therefore, then this is however, usually the condition, like I said, are that he'll make himself available for interrogation by a police officer as and when required, and shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the facts. And then in certain cases shall not leave India. And then, of course, it can be any other condition which can be imposed considering the facts of the case. However, there are little more stringent provisions when it comes to offenses under the 65 subsection 2 of which says that if in case of rape, if the prosecutrix is under 12 years of age